Hello, good afternoon, everyone.
Hey, Ana Maria.
Just a quick note that I tried to hit share screen just now to figure out whether it would work for me. It looks like that's not enabled for me. Keith, are you able to see if that works for you?
I will make you a co-host and then you should be able to do it. Give me 1 second.
Great, wonderful, thanks.
Yeah, Samantha, then I would need to be a co-host as well because we're going to flip back and forth.
Can you test it out now to see if you have that capability?
I will try. Looks like I can. Yeah.
Same here.
Awesome. We'll give folks just a few more minutes to get logged in. And is it Anna or Ana?
Oh, thanks for asking. It's Ana Maria.
Ana Maria. Okay, thank you.
Sure, no worries.
We'll go ahead and get started. So everyone that is aware, this is being recorded. My name is Samantha Sliney. I'm the Pro Bono Director for MSJDN. We have with us today Ana Maria and Keith, both from the Veterans Consortium, who have graciously agreed to give us an overview of pro bono opportunities with the Veterans Consortium. Ana Maria is a staff attorney from the Discharge Upgrade Program at the Veterans Consortium. And Keith serves as a staff attorney with the case evaluation and litigation team at the consortium. And with that, I will turn it over to both of them to give us an overview of their pro bono opportunities.
Great. Samantha, thank you so much. And this is Keith Krom. First off, thank you for welcoming us. It's an honor to be able to talk to you a little bit about TVC and our pro bono program. My charge is to kick us off, give you a brief history about the Veterans Consortium, our pro bono program, talk in very broad strokes about our core original mission, which is representing veterans before the Court of Appeals for Veterans Claims, and then also introduce some of our now prominent ancillary service lines dealing with our clinics, and then turn it over to Ana Maria, who's really going to give you a deep dive on our discharge upgrade program. So with that, let's see if we can make technology work. So this briefly is our creed, what we try to do, our mission statement. It's really to help veterans try to get the benefits and services they need and deserve after serving our nation. So again, just quickly, the agenda, what I just spoke about and what we hope to accomplish. And really the focus will be on the discharge upgrade and the issues that Ana Maria will talk about. So Congress created the Court of Appeals for Veterans Claims in 1988. Soon after its creation, the court quickly realized that about 80% of the appellants were proceeding without any legal representation. So the court, with the approval of Congress, provided a portion of its annual appropriation to the Legal Services Corporation. They sought proposals to create a program to provide pro bono representation to appellants at the court. In 1992, 4 national veteran service organizations, the American Legion, the Disabled American Veterans, the National Veterans Legal Services Program, and the Paralyzed Veterans of America, formed the Veterans Consortium pro bono program. And they submitted what turned out to be the successful bid to undertake that representation at the Court of Appeals. So the challenge is that annually, there's about 8,000 appeals docketed with the Court of Appeals for Veterans Claims. And once those cases are docketed and move along, VA generally assigns an attorney to represent the agency in each one of those cases. There's still a huge portion of veterans who are appearing before the court without any representation. And that's where we come in. The Veterans Consortium Pro Bono program has a dual mission. The first is to provide assistance to unrepresented veterans or their families who have filed appeals at the court. And the second is to recruit and train attorneys in the field of veterans law. There's about 1,200 pro se veterans annually that come to the Veterans Consortium and ask for a pro bono attorney in their appeals pending before the court. So what do we do? Our program is made up of 3 components. There's the client services component, which is really the frontline team for case intake, case management, and TVC office administration. They're really the folks who field questions from veterans, help them fill out the forms, track the paperwork at the court to make sure everything is proceeding appropriately in order for the veteran to be represented in the matter. There's the case evaluation and litigation team, which I'm part of, and we evaluate the veterans' cases when they ask us for help, and we outline any potential legal arguments that may exist, and we help match those cases with volunteer attorneys. And finally, there's our outreach, education, and placement team, and they work with training and mentoring the volunteer attorneys. They also are heavily involved once the case is assigned to a volunteer attorney to make sure the court's deadlines are moving according to schedule and make sure nothing falls through the cracks. In addition to that main focus, we offer some complementary services that I'd just like to highlight. The first is we staff a pro se helpline. So working with the court, again, there are many veterans who decide that they may want to proceed without having an attorney. It may be the fact that they think they know their case better than anybody else, which is probably true. So they decide that they want to be their voice and the main advocate for their case at the court, but they still have questions about some of the procedural issues and requirements that the court issues as far as filing an informal brief or responding to a motion. So our staff staffs this pro se helpline to actually field those questions and to help guide the veterans to maneuvering around the court's procedural systems and making sure that they get a better understanding as to what they need to do in order to have their case proceed. The other item I have listed here is a pilot program, and it deals with Rule 33. So at the court, they have a mandated mediation program. So before the briefs are filed, the court requires that the attorney for the veteran and the attorney for VA actually get together with staff for the court's legal services team and to discuss the case and see if there can be an agreement as to whether there's any errors that occurred below, whether there's any legal issues that need to be remedied. And those mediation conferences often result in the case reaching a settlement where the case may be remanded back to the Board of Veterans Appeals, or in some cases even be settled and the veteran provided benefits. The problem with that Rule 33 requirement is only attorneys can participate in that mediation. So again, if you're one of those pro se veterans, you're not allowed the opportunity of a mediation session, and you're probably missing out on the possibility of having that case reach a settlement and be remanded. So we started a pilot program where, for the limited purpose of that mediation conference, we also will try to find an attorney to represent that veteran pro bono, represent them at that mediation conference, and have them go through the issues and hopefully reach a settlement on their case and have it be remanded back to the BVA. That pilot program has been very well received, not only by the court, but by VA attorneys, who also see this as a possibility of moving cases along faster and getting the issues resolved. That pilot program is going to proceed up until May of 2023. And then we'll have to see what happens with the court after that date to see if that program is extended in some form. And then finally, what we do also in case evaluation is, this is one of our perks. If when we're looking at a case and reviewing a veteran's file and the decision, there's something that just stands out and really piques one of our interest, we're allowed to take that case on ourselves and directly represent the veteran. And that allows us to not only participate directly with the court, hone our skills, but also take on one of these representations ourselves and help veterans even further in that respect. So again, what this program does is that it allows volunteers to participate and help veterans really almost at their last stage of an appeal and trying to preserve their case. We go out, recruit and train voluntary attorneys and paralegals in veterans law. Much of our training is eligible for CLE credits. We, again, carefully screen cases for merit. We provide litigation strategy and maintain a secure website with the latest cases available as far as resources for any of our volunteers. We provide experienced mentors to help out with any questions our volunteer attorneys may have along the way. We provide malpractice insurance if necessary, if you're not already covered by your own employer. And we support the attorneys and clients throughout the whole process. One of the great things about the CAVC practice is about 75% of the cases can be handled from start to finish in less than 30 hours. So it's a nice, discreet way of serving the veteran population and making a true difference for a veteran. Some other things just to highlight, the opportunities, you can tap into it anywhere. It's pretty much a pleadings process, so you can volunteer remotely and pretty much handle the case start to finish. And you gain some significant federal court experience, not only in reviewing what could be oftentimes very, very complex records, but you get direct client interaction and counseling with your pro bono veteran. You get to analyze, again, the record and write briefs firsthand. And you again get to negotiate during those mediation sessions. I think one of the other key things to point out is you actually have a real chance to be making new law in this arena. There's been significant changes to veterans benefits laws in the past few years, actually most recently with the PACT Act passed in August. Many of those issues are going to be issues of first impression as they make it through the Board of Veterans Appeals. And those cases, again, will be issues of first impression when they make it up to the court. So there's a chance that when you tap into one of these cases, it'll be the first time that the court is going to be considering that issue, and you have a chance of actually paving a new way in veterans law. So let me just briefly introduce the other service lines that we offer. We have a free legal advice clinic that we also host. Volunteer attorneys work with volunteer law students and interview veterans, conduct issue spotlighting, and refer those veterans to the appropriate legal aid organizations to help them get relief with their legal matters. The clinics are open to all veterans in DC, Maryland, and Virginia, regardless of their discharge status. We also offer our Women Veterans Legal Advice and Referral Clinic. This is one of 3 legal clinics in the nation specifically for women veterans, and it's exclusively staffed by women volunteers. And then finally, we offer our Veterans Naturalization Assistance Program. The VNAP assists veterans who are applying for naturalization through military service. Our volunteers are trained to assist veterans with their naturalization applications. They learn how to gather the appropriate evidence needed to support those applications and write defenses. And they ensure that the applications are properly completed. As with our other programs, we have specialized attorneys, in this case, practicing immigration attorneys, who serve as mentors to those volunteers when needed. With that, I'm going to turn it over to Ana Maria. And I think I need to stop sharing, so I will stop.
Thanks very much, Keith. Let's see if we can make this a seamless transition. Oh, okay. Postpone. Let's see. It looks like some IT update was requesting to start just now, which is perfect timing. Let's see. Can everyone see my slides?
Yeah.
Great. Well, we don't need to start from the beginning, luckily. All right, this is where we need to be, I believe. Thank you for bearing with me. Again, this is Ana Maria. For the remainder of the time, I'll give you an abbreviated version or sneak peek into our training for discharge upgrade volunteers. What you see on the slide is the criteria we apply because the demand for discharge upgrade services is very high. Now, not a lot of people do this work, and we're here to support folks who want to start. In general, those criteria I mentioned, OTH with a mental health diagnosis, often trauma survivors, whether that is combat or military sexual trauma. We abbreviate that MST for military sexual trauma. For MST cases, we may be able to take if the discharge was general or general under honorable conditions. Now, I know this is a lot of alphabet soup. For this audience, it's likely something you've been exposed to before. I will try my best to define abbreviations as they come up. And please do let me know if you would like more clarification. More on the types of discharges in just a minute. We come to our first objective here, first discharge upgrade objective, which for many veterans is the underlying reasons why they contact our discharge upgrade program. So our objective, to understand why some people who served in the military are not eligible for veterans benefits and how you can help. My last slide will have contact information for folks who want to volunteer, as well as the number that veterans can call if they're seeking legal assistance with a discharge upgrade. As promised, here is that list of some of the most common military discharges, with just a quick and dirty note about what the discharge might mean for access to benefits. So what are the options for what it can say on that discharge document, that DD-214? First, right at the top, fully honorable, which is what most veterans receive. It does not mean that service was perfect, far from it. There's a lot of discretion after some minor misconduct whether to separate and which of the 3 administrative discharges the veteran can get. So one lower than fully honorable is general under honorable conditions. The major benefit that a veteran loses out on with a general is the GI Bill, so education benefits. There may also be state level benefits that require a fully honorable and a general won't do. Then that OTH, other than honorable, formerly known as undesirable. Again, this is where most of the cases have to be in order for them to meet our criteria at the discharge upgrade program. An OTH is still an administrative separation, meaning there is not a trial, there is not a court-martial, sentencing, or requiring a discharge. The 2 punitive discharges, bad conduct and fully dishonorable, those can only happen after a court-martial. These discharges are where the veteran probably will not have access to any benefits from the VA unless they win their discharge upgrade or another exception applies. And these cases with the punitive discharges, they are some of the most challenging because from the board's point of view, the military at great expense provided a trial and opportunity to be heard back then. The boards apply a presumption of regularity that all the rights of the veteran, or at the time service member, were afforded, including often the right to an attorney to represent them at that court-martial before discharge. We don't see them as often, but there are other possible discharges, such as uncharacterized or dismissal for officers. It is a case-by-case basis whether a veteran is able to access some or all of VA benefits and services, depending on their discharge. The Army used to have a chart online for benefits at separation or benefits at discharge. I have the permalink here on the slide, and it is also in the Veterans Benefits Manual as an appendix. Remember, the inquiry is case by case, and exceptions may apply outside of my earlier overview. Although handy as a reference, the chart features those rigid lines, and that may prove to be misleading. I want to take a moment here and emphasize any discharge less than fully honorable can be highly stigmatizing to a veteran. It is so important not to add to the stigma, and we really advocate not using the term bad paper. Our clients experience exclusion from benefits, exclusion from veteran communities, and many talk to us about internalizing that shame for decades after they leave military service, when they might have intended to make the military their career. Yes, less than fully honorable conditions, a bit of a mouthful and longer to say, but our view is that with the words we choose, we want to build trust with clients and potential clients, show them we want to hear and lift up their side of the story, and try to build a strong case with them. With the next couple of slides, I'm just pointing out some of the intersectionalities at play. Advocates are paying more and more attention to how gender and race identities affect the experience of our service members and veterans. I also want to share, again, we have the Women Veterans Legal Assistance Program that Keith spoke about earlier. And one of the reasons for that targeted outreach is we know many women who served don't identify as veterans. It could be because of their historical exclusion from combat roles, or it could be they're not made comfortable in male-centric spaces like VA clinics. Many other reasons or combinations of reasons can be at play. Our view is that their service absolutely does count, not to mention VA's data that women veterans is the fastest growing demographic. Just some more resources here for further reading. And if you are a fan like me of studies or law review articles on the subject, there are a few more I can recommend to you if you'd like to reach out after the presentation. Suppose a veteran with an other than honorable discharge tries to get treated at a VA hospital or clinic. What can they expect? If they're lucky, they receive accurate information about emergency mental health care and services specifically for MST survivors. Again, that's survivors of military sexual trauma. More often, some overworked and undertrained employee sees the DD-214, sees that OTH, and tells the veteran they are not eligible, or worse, not considered a veteran. Again, this is not what VA's official policy is, but we have veterans across the country sharing this experience with us time and time again. This experience of having the VA turn them away. What is supposed to happen is a character of discharge determination, COD, and one problem is that VA hospitals do not do CODs. It is the Veterans Benefits Administration, still within the VA, but a different section. COD is not as well known as discharge upgrades, and the two have enough similarities that if you're not paying close attention, you might mistake them for the same thing. The regulation VA applies is 38 CFR 3.12. We won't get too deep into it, but after a COD, there are only two options. The VA finds honorable for VA purposes, meaning the veteran can go on to apply for benefits even without a discharge upgrade, or dishonorable for VA purposes. Again, that stigmatizing language comes back into play. Most likely, VA will deny compensation and healthcare, the two big benefits. And again, if the veteran had no prior discharge that was fully honorable, they would not be eligible for the GI Bill, even with quote unquote honorable for VA purposes after a COD. Although VA has its own regulation and its own path to appeal on up to federal court, a lot of the evidence for COD and discharge upgrades are similar. Personnel records, medical records, both during and after service, character letters in support, expert opinions. Remember that COD and discharge upgrade are different, but nothing prevents you from trying both avenues pretty much at the same time. So why do some veterans get barred? Because of their discharge, OTH or worse. How can we help? Clarify the misconceptions that are out there. Help veterans apply for COD, character of discharge, discharge upgrade, or both. Let's get into our first checkpoint in hypo, and I'm going to take a quick peek at how long we're going here, doing well on time. Keith, would you mind reading that hypothetical for us, please?
Sure. Max was discharged from the Marine Corps with an other than honorable discharge. He served from 2001 to 2011, 10 years total. He completed his first term of service with an honorable discharge, then was discharged due to misconduct resulting in the other than honorable discharge for his final term of service. His DD-214 states other than honorable and misconduct. He goes to the VA clinic to enroll in healthcare. Is he eligible for VA healthcare?
Yes, the big question there, is he eligible? Maybe we could, oh, listen, looks like we have a hand raised for Jenny Campbell. Thank you to our brave volunteer. Samantha, do you think you could help enable Jenny's mic?
She should be able to, I just did that and she should be able to talk now.
Oh, I thank you. I also have a celebrity sighting. Looks like our executive director, Steve Jordan, is on the line as well. Let's see if Jenny can start first, if you don't mind.
Hi, sorry, this is Jenny. I accidentally hit the hand raise. I don't have a question.
All right, no problem. Care to take a stab
Sorry.
while we have you? No, no worries at all. No pressure. Okay, we'll take a look at that Q&A later. As Steve, if you have something to say, please feel free. Otherwise, I'll just go through one or two things we're hoping to point out with this hypo.
I'll take a stab at it. This is Sam. I think it would be at the discretion of the VA. And I'm just basing off my JAG experience in our AFIs. It basically says it's up to the VA on whether or not the healthcare, what healthcare services they may be able to get.
Yeah, certainly. I agree. So what going off of the earlier discussion, what should happen is that COD, character of discharge determination, not at the clinic or hospital that Max tried to go to for healthcare. The Veterans Benefits Administration should review his records and any evidence he submits, apply their regulation 38 CFR 3.12. And as Sam points out, there is a lot of discretion in applying that regulation, especially because there's some very broad language about whether misconduct was willful and persistent, for example. The VBA will decide whether they'll find him honorable for VA purposes, provide wraparound healthcare if so, but if not, just emergency care or care related to military sexual trauma. If that applies, it's not included in the facts that was part of Max's experience. There's something called Chapter 17 eligibility, which is a sort of niche topic. So if the VA decides no on veteran status, but agrees that Max incurred some sort of disability during his 10 years of service, they may find him eligible for care limited to those disabilities. So you might hear from time to time Chapter 17 eligibility only. Not compensation, just medical service. And again, medical services limited to what the Veterans Benefits Administration finds as service connected. Okay, so moving away from VA COD to some of the more nuts and bolts of discharge upgrade. The burden of proof is on the veteran to show impropriety or inequity and ask for relief. There's no such thing as an automatic upgrade ever. Between the date of discharge and the 15th anniversary of the date of discharge, the veteran has certain rights before the DRB, the Discharge Review Board. There's one DRB for each branch of service. The DRB has limited power, but it is a lot of the most frequently requested and useful changes. For example, the DRB can recommend change in the character of discharge, narrative reason, and various codes on the DD 214 that tell you about what happened to end the veteran service and whether they could rejoin or re-enlist in the military. At the DRB, it is best practice to ask for documentary review only at first. Then if needed, the veteran can have a second chance or a second bite at the apple at the DRB by asking for a hearing. These hearings have been telephonic only since the COVID-19 pandemic. And again, harkening back to some of Keith's comments earlier, again, because we serve veterans all across the nation, the opportunities are there for remote service, on your time, meeting any deadlines as needed. For the veterans, the statutory right to a hearing expires at 15 years. So that is the main deadline that we keep an eye on in discharge upgrade work. Again, there's no waiver provision for that 15-year deadline. So once 15 years is up, the DRB loses jurisdiction. Here's a little bit more on what evidence we recommend. As you might expect, some of the official records could prove useful, but often that's not telling the whole story. That's where medical records, character letters, proof of what the veteran has been up to since discharge. You can help gather and advise the veteran on how to put all that together and put their best foot forward for the board. At the bottom of the list there, the last one about a doctor or therapist letter and opinion on mitigation. That comes from some of the more recent policies that the DRBs are supposed to follow. Speaking of those policies, we're lucky that some recent guidance memos give veterans a better shot at getting relief. We're still waiting for the PACT Act version for discharge upgrades, but these policies are still something that we quote to the boards and really show off the reasons that they're empowered to grant relief. The DRBs have really broad range to find impropriety or inequity. And by some studies, unfortunately, the boards are denying a high percentage of applications in the 90% range or more. So we think that that's why some of these policy memos started to get pushed out. In the discharge upgrade world, liberal consideration is huge. That's what the Hagel and Curta memos explain. When might liberal consideration be appropriate for applications based on mental health or experiences like MST? For great language on why post-service conduct is relevant to discharge upgrade, look no further than the Wilkie memo. Each memo is very short, and we do quote them to death to the boards, like I mentioned. Highly recommend you read through them when preparing a discharge upgrade case. Although the memos are helpful, and we're hoping that increased training and awareness in the bar is moving the needle towards higher success rates, it's still far from automatic that a veteran gets an upgrade if they show they had PTSD or survived MST. It looks like we're here at our second learning checkpoint. Keith, would you mind doing the honors again?
Sure. Alex was discharged with an other than honorable discharge on October 30th, 2004. He served 6 years in the Army and had multiple combat tours in Iraq and Afghanistan. He was discharged due to drug use after he returned from his combat tours, suffering from PTSD. Should he apply for a discharge upgrade at the Army Discharge Review Board?
What do we think? Is there anyone that might have a thought to share? With this example, there are a couple of things that we wanted to review, and hopefully the answer you had in your mind is along the lines of what I'll discuss here. First, we want to make sure the branch of service and branch of DRB match. Remember, there's one for each branch. Alex was in the Army, so a DRB looks right. But remember that 15-year statute of limitations, that is not waivable. So if Alex is trying to go to the DRB, perhaps he was interested in exercising his right to a personal appearance hearing. That right unfortunately expired, let's see, 15 plus 4, so in 2019. So there's no facts that show he preserved that right, and the board has lost its jurisdiction over his request for review at this point. But not to worry, there are higher review boards that review upgrades, and they do routinely waive their statute of limitations. It's technically 3 years, but it's a low standard to grant that waiver. Just a waiver if waiver, excuse me, would be in the interests of justice. Instead of impropriety or inequity, the boards for correction review for error, injustice, or clemency. Practically speaking, when you're looking between impropriety and error, there's not a huge difference or no difference. Same thing if you're comparing inequity and injustice, no huge difference, right? To synonyms and used interchangeably. But one way to show the board that you know what you're talking about is to use their language, right? Just like at the DRB, for each branch of service, there is a board for correction. The boards for correction can recommend more types of changes than the DRBs. For example, they can restore rank, amend dates of service, and make name changes for transgender veterans. Again, the standard they apply: should we make this change? Was there an error? Was there an injustice? Or for clemency reasons? Remember the guidance memos we touched on earlier: Hagel, Kurta, Wilkie? The boards for correction do apply those same standards as well, and so be aware of the potential for liberal consideration at both levels. And then again, just to show not a huge difference between the standards that the boards apply in practice. A main difference between the DRB and the board for correction: again, no right to a hearing when you get to that higher level. Prepare as strong an application package as possible. The board members are not active duty officers like they are at the DRB, so know your audience. It's possible that at the board for correction level, the members may be more receptive of evidence to show rehabilitation, evidence of positive post-service conduct, etc., more so than the DRB. But again, the Wilkie memo applies to both. There's no correction or review board, DRB, BCMR, or BCNR. None of the above have authority to grant VA benefits. All they can do is authorize changes in military records. It is usually that DD 214 that may form the basis for a successful application to the VA. But the application is separate from discharge upgrade. Again, two possible strategies to help a veteran restore their benefits inside and outside the VA. I do want to leave plenty of time for questions at the end, so I'll just preview this topic of DAD-T, don't ask, don't tell. Remember when I mentioned that there is no such thing as an automatic discharge upgrade? That holds true here. Between 1994 and its repeal in 2011, DAD-T, don't ask, don't tell was the official military policy for LGBTQ service members. Before that, homosexuality, homosexual acts, homosexual admission, these are things that could be prosecuted at court-martial. So if you remember back to the list of common discharges, if outed, the service member could receive a fully honorable with that narrative reason referencing their sexual orientation or perceived sexual orientation, all the way down through the administrative discharges to being punitively discharged for being LGBTQ. Our director, Christy, is actually doing a 1-hour training on Don't Ask, Don't Tell currently. This is a topic that, again, even with high demand for our discharge upgrade services, we feel strongly that we need to get the word out about this type of application. Since the changes or upgrades aren't automatic, many LGBTQ veterans who, again, maybe have never identified with that label veteran are out there and need help to reclaim the honor they earned through their service. We also have upcoming in-depth trainings on discharge upgrades or our other lines of service. If you're interested in becoming a volunteer at TVC, I think there was at least one question related to that in the chat, or our other lines of service, not just discharge upgrade. Here is the contact information to get your name on those lists and hopefully proceed to training and helping vets out there. I sincerely thank you all for your attention, and I look forward to a discussion and Q&A.
Thank you, Ana Marie and Kevin. And I'd also like to point out that Ana Marie is a military spouse, so she has connections to MSJDN. I would be remiss if I did not mention that. We do have one question. It says, in addition to providing pro bono services, I am interested in adding veterans disability law to my firm's practice. Would there be any conflict in participating in the pro bono program and later using the information gleaned to charge a fee for representation to private clients?
This is Keith. There wouldn't be any real conflict, assuming you took one of our cases and took on a veteran pro bono and completed those obligations. most importantly, by not charging that specific veteran for your legal services. You can definitely use the education you receive from us to venture on and represent other veterans. Many attorneys have done that. And in fact, as I pointed out, one of our core missions is to train attorneys and paralegals in veterans laws so that veterans do get satisfactory representation. So there should be no issue there.
For sure. And again, not a lot of folks have competence in handling clients that have experience in the military, right? You know, we have a variety of ways for you to be involved if you would like to be. And, you know, at least on the discharge upgrade side, what you can expect is a case that we've pre-screened, you know, has great merits, especially under the recent policy guidance, and really a veteran that likely has waited years for their chance at a strong application, you know, and, you know, the more that we can help through our program, the better. And we really see it as part of our mission as well to strengthen the bar's knowledge in this area.
If you have any questions, you don't want to type them in, raise your hand and I'll can turn on so you can talk instead of type. All right, Jennifer.
Hi there. I think I may have missed earlier. I'm sure you gave an explanation for the difference in the legal clinic program and the Veterans Pro Bono program on the screen that you're showing us right now. I'm in the DC metro area, so can you comment what the difference is in those two programs?
Sure. Keith, do you want to take that one?
Sure. So this, in addition to the discharge upgrade, we have four other programs that really focus on veteran services. Our core one is representing veterans before the Court of Appeals for Veterans Claims, and finding them representation, pro bono representation. We also have our legal clinic, which is open to veterans in the DC, Maryland, and Virginia area. And that pretty much helps eligible veterans bridge that legal gap of trying to get their potential legal issues not only answered, but we try to also put them in touch with the appropriate legal aid services that can promote those issues and help them get resolved. We have our Women's Veterans Legal Assistance Program. That's one of 3 legal assistance programs devoted exclusively to women, and it's staffed by women attorneys and volunteers. And Ana Maria touched on some of the specific issues and sensitivities involved in that program and how we help women veterans. And then the last is our Veterans Naturalization Assistance Program. There's many veterans who never really applied to become citizens, even though they did serve in the military, and our volunteers help gather the relevant information necessary to fill out those applications and help those veterans fill them out correctly and get those filed so they could become citizens.
Yeah, I'll share this if I can. It's one of my dreams for someone to come through the door that all our lines of service can affect and impact positively. You know, perhaps they're starting with another than fully honorable discharge. We get it bumped up to at least general or fully honorable, you know, remove those barriers to accessing benefits in terms of compensation, remove that barrier to accessing expedited naturalization, somebody who fought for our nation but never received their citizenship, maybe had some minor misconduct in the end. We clarify that connection to mental health, at the same time establish the diagnosis and service connection, you know, all the way up. You know, one day I hope that veteran's there and you know, just be the poster child for all our services.
Looks like we have.
This is Jennifer again.
Sure, go ahead, Jennifer.
I had done a military justice CLE program earlier this year, and the speaker had talked about some different applications that the attorney has to complete in order to be accredited to appear before the CAVA? I don't think I heard you all talk about that, and maybe I'm confusing apples and oranges, but can you comment on whether there's any applications we have to do?
Sure. So specifically for the Court of Appeals for Veterans Claims, depending on how committed you want to be, you can take on a case and receive their version of pro hoc vice, which allows you to represent that veteran before the court for that specific case. You can only use that card once, but you're able to do that. Putting that aside, actually getting accredited before the court is quite simple. You just have to show that you are a member of a state bar. You have to provide the official authorization from the state bar itself, not the bar association, which sometimes gives you the certificate of good standing. You need the actual certificate of being able to practice before that state. And you just submit a copy of that with some relevant information on the form, and it's pretty quickly turned around, assuming you dotted all the I's and crossed the T's. So it's a pretty easy experience.
Sounds a lot easier than getting waived into a new state if you're a military spouse following your service member around.
Definitely.
We have another question in the chat. What work does WVLAP do as compared to the federal Veterans Pro Bono program?
I'm not sure I know of the distinctions between the federal program and what we do. I'm sorry.
Oh, just the way we have it on the flyer here. The one at the very top is our core mission, right? So representation at the CAVC, and those veterans can be located anywhere in the nation, right? So then second to the last one down, specific to women veterans, a woman veteran certainly could have an issue at the CAVC level, but for that specific clinic, again, if they have another legal issue, potentially they could be served there.
Any other questions before we close out? Kevin or Ana Maria, any closing comments?
None other than, again, thank you all for making the time. We are getting inquiries already from folks in the Pro Bono Committee or the MSJDN network in general. So we look forward to hopefully helping more veterans and increasing awareness of these topics. Thanks again for the invitation.
Yeah, thank you.
Absolutely. Thank you both for your time. We appreciate it. Thank you for the attendees for dialing in. This will be recorded and will be posted on the members only portion of the MSJDN website. So if you want to go back and rewatch, you missed some of the information, please go back and grab that and then reach out to the Veterans Consortium if you would like to start volunteering. I hope everyone has a great day. Thank you.
Thank you. Bye-bye.
Bye-bye.